started, if that's okay. Marley's texting me backwards and forwards at the moment, so let's go. So, hi everyone. Good morning from Australia on the 18th of March here in Australia, in Melbourne, and a very good afternoon to everyone in the Northern Hemisphere. And as I said, I know that we've got people calling from all around the world, and I guess, you know, that is the power of ILEA. And to each and every single one of you today, you know, the incredible ILEA family, I really want to say we will get through this. You know, will we get through it unscathed? Probably not. We're going to have the usual, you know, cuts and bruises and the wind knocked out of us a little, but I really think that together, you know, we are going to prevail. Because you have ILEA as your support, your network, and, you know, we've always stuck together. We've done it before and we can actually do it again. So we certainly do need each other. In fact, you know, over the weekend as we were, you know, fielding so many emails and calls and things, as you can imagine, and my husband said to me, you know, thank God you've got ILEA. And I thought, absolutely. I mean, if there's ever a time when I thought, wow, you know, the value I got out of a membership, you know, I won't actually ever do that again. It's certainly, we need you and I need you. So, and we need each other. But I will put my hand on my heart and say, you know, yep, it has been tough. But absolutely this, you know, ILEA board of directors and our RVP, seriously, they're the most resilient and professional group of people I've actually worked with. And, you know, through lots of our discussions, we know that we need to keep you updated, you know, with the facts. We know that we need to provide you with resources for, you know, managing people and your businesses in a crisis. We definitely know that we all need to move away from the negativity of the press and the social media. And we want to provide you with solutions and, you know, give you support that you need. We don't have a silver bullet, but what we do have there is the resources. We have your back. And you have an amazing global group of brains and energy that are here for you. So I think one of the key things out of this is that you must tap into that, and we must stay connected. You know, I think we've always had a very loving and strong community, and we need to ensure that we look out for our fellow colleagues and ILEA people. And, you know, by that, I mean, I was talking to a few people yesterday about this, that I mean, everyone's mental and emotional health. You know, this is not just about business. You know, this is us being told to self-isolate. And, you know, that's bloody tough for us, because our industry is about getting together and kissing and hugging and networking and face-to-face and interacting. And we need people. So, you know, I do invite you that, you know, straight after this webinar, reach out to a couple of your ILEA colleagues or industry friends. You know, are they okay? Share a glass of wine over a Zoom call. I was listening to the radio this morning, and someone else is doing a dine online session with their mates on a Friday night. You know, talk about how you're spending your time in a positive way. You know, how you're working through this change in your business, but please just stay connected. That we stick together. So I just want to switch gears, and I just want to switch gears and get into the nitty gritty of today's webinar. And I hope you can see those slides, because I can't see them come up right now. Jeff, can you see them?
Yeah, I can see them. Just got to go back.
Okay. So am I okay to go forward with the slides, Marley, because I can't see the slides on my screen, so apologies, everyone.
Yeah, you're good. You're good, JT.
Okay. So first I just want to outline some of the ways that ILEA is providing our members with key resources, you know, throughout this sort of unique time period, and as well as providing some opportunities to connect as a community. I'm also going to give a brief update on some of our ILEA strategic initiatives, and many of you have been asking about. And also, most importantly, I'm going to be welcoming Jeff Tenenbaum. And as you would have seen online, he's an experienced association and not-for-profit lawyer. and he's going to review some, specific legal considerations for event professionals and clients during this pandemic. But we felt it was really important to provide a resource to the entire events industry, and it gives support to you, as we have to make some hard decisions for both clients and our businesses over the next, few months. Just an FYI, we've also allowed time for as many questions as possible following Jeff's presentation, and then after Jeff's presentation we can go into some specific ILEA questions. So just let's start with an update on our COVID resources from ILEA. For a few things. First of all, we have mobilised a team of us to stay focused on communicating with our members during this time, and also providing helpful resources on a consistent basis as information comes to hand. As you are aware, and because I've been obviously on social media a fair bit, we've asked all chapters to postpone in-person meetings, and I know that many of you are in lockdown, but we have made this decision for obvious reasons, because we know that COVID-19 and with the safety of our membership in mind, we must do that. I mean, our priorities in tandem are to flatten that curve and spreading the virus, and also to continue to foster our events community, which is incredibly important for us, as we all know. Many chapters, which is great to see, being very proactive. They're hosting online sessions this week, sharing educational content regarding COVID through webinars, online forums. But please, I do ask you if you could support your local chapters and certainly go online onto the websites for more information. On the weekend, it's amazing what 48 hours, Thursday, Friday, it was okay, then just everything turned, it was difficult. On the weekend, we added, so we actually got together, we added a click-through on the front page of our website. That is the ileahub.com. It's got a collection of resources related to COVID. That page is going to be updated regularly for you. Everything will be stored on that link. So many of you have actually gone into our website to click on for this webinar. Everything's going to be on there. This is being recorded. That'll be uploaded to it. All the sessions for this week will be recorded and uploaded as well. We encourage you, please to utilise the ILEA community. We want people to share their thoughts as well as resources and solutions that they've implemented already in this difficult time. I know people are craving advice. I know they want guidance and ideas to help them move forward. So we need all of you to contribute on those pages, and as I said, stay connected. And of course, if you prefer social media, there's lots of things happening on the ILEA Connect Facebook group, and also following us on Instagram. So let's just move to the online forums. We've put a lot of work into the last 48 hours. As I mentioned, it's really important for us to stay connected. We've coordinated some further initiatives to foster connection and keep our members talking. We're hosting a handful of online conversations and education forums this week. And these forums, just so everyone knows, because I'm getting a lot of emails and texts about, is it for non-members as well? Yes, it is. We want to engage, and we're communicating with the entire global events industry. So tomorrow we're going to come together again as a community for our first ILEA Strong Forum. Sarah Gruff and I are going to be moderating that session. And that's intended to be a positive experience. We want to give our members a platform and a place to congregate, discuss, share resources, ideas for getting through this, and also a feeling of sense of togetherness, which is really important. So on Thursday, we're hosting an education webinar, and that's about taking your meetings online. So that'll be really useful for everyone, because most of us are working from home. We're going to cover the basics of using Zoom, various account settings to consider and tools to use to maximise your online event, and a number of Zoom best practices. Tiffany Rosier, RVP of ILEA Southeast, she's been driving this great initiative, and she's been enormous help as well. So once again, that's open to everyone and anyone. And then next week, we thought we would also lock in another ILEA Strong forum, just to see how we go and how well attended is tomorrow. That's going to be more around the spirit of collaboration and discuss our collective plans for recovery. We want to focus on the rebuilding, the reconnecting, and us being resilient. So please save that date for those important conversations. That's on March 25th at 3 p.m. CT. And finally, I want to touch on our ILEA strategic initiatives, because we've been doing a lot of work leading up to now. Give you a high-level update. As you know, we originally planned to host our member town halls this week to provide updates on our strategic initiatives. You know, since the board left Minneapolis, you know, we've really hit the ground running and working on our strategy. But while we've actually postponed those topics for a later date, I'd really like to give everyone just a quick update on a few things, because we have received questions due to COVID, you know, from many of our chapters. So first of all, the ILEA International Leadership Nominations. The application deadline has been extended to March 31. So please, still, I know it's hard to focus, but please have a think about that. You know, we need you, we need your expertise. We need your brains around the table. So certainly, you know, reach out to Sarah Graff or Marley or myself, or anyone on the board if you wish. But certainly, we'd love to see people apply for those roles, international roles. And as I said, that's extended to March 31. The Esprit Awards, I think that you saw a lot of emails go out about that. The submissions deadline has been also extended to March 31, and also huge thanks to JC York, as always, and also Jim for driving that. And also the SOE Awards as well. I think Megan Johnson's doing a great job on that as well, working with Jim. So thank you so much for that. CSEP, we've got a team of leaders who are continuing to advance the rewrite of the CSEP exam. And please, if you're interested in supporting their rewrite process during the time, Corinne Kessel, as you know, is a director on the board. Look, please reach out to Corinne. Her email, I believe, is on the slide. But we really do need your help. We thought while some are working at home, we may be able to ask for your expertise in this area. And ILEA Live. Wow, we can't predict the immediate or long-term future, but I can say that as of today, our intention is to continue with ILEA Live this summer. Our decision obviously is hourly at this point as new information emerges, but we will provide obviously further updates. But seriously, the work that Morgan and Dana and the task force has been putting into it is just absolutely brilliant, and we can't wait to share it with you all. So please, let's all pray that this does go ahead, because I think it's really important as well. I think all of you agree, is to be able to at least to get together in some shape or form would be amazing. So that's it from me. I may catch, sorry, I'll introduce Jeff in a moment, but as I said, please, we must stay connected. Email me as you've been doing, ask questions. Please also, if you want me to give you a call, I can ring you at any time. I've already got several calls locked in to talk to many of our members in the UK as well as America, Canada. So please, I'm more than happy to have a chat to you and just help you, any ILEA members. I cannot thank enough the headquarters and our board. You've just been absolutely incredible. We've all been agile, you've all been accessible, and I think everyone certainly, I think Tom Cura, who's the head of our international members committee, did put on Facebook yesterday that, you know, in times of adversity, this is when we become stronger, and together. I think that's actually what's happening at the moment. So, you know, for those who know me really well enough, you know that I'll do whatever I can for you. Whether it's, you know, helping with business as well as just being support. So make sure you reach out. We love you, we're thinking of you, and we just know that we can get through this together. So before I welcome Jeff, I think I'm going to hand over to Marley. She's going to talk about some of the logistics with how to type in questions and etc. So I'll hand over to Marley. Questions, we'll just keep on talking until everyone's you know, we're not going to cut the webinar off. We're going to continue, and then we can go into ILEA stuff. But thank you everyone for taking the time, and we're with you all the way. We're here for you. Over to you, Marley.
Well, I'm really excited to see that we have about 325 people on the call with us today. What a great turnout and such support from our ILEA members. We're so excited to have you on. If you have not used Zoom before, just a couple of things to note. There's some mute and unmute features. Right now, none of our participants except for panelists have the ability to mute or unmute themselves. If we need to unmute you for a question later on, when we get to the questions at the end, we will definitely do that. You simply just use the raise your hand feature and we'll go ahead and we'll coordinate that. Other things that you will see is our chat box. So if you look for the quotation bubble and you want to join into the chat, go ahead and click that and it should pop up for you. I can see a lot of you have already found that feature and have been using it, so that's exciting. You can also choose whether or not you want to just chat the panelists, if you want to chat just me, the host, and we'll all be able to see and answer any questions you have there. Again, we have the raise your hand feature. You can go ahead and click that, and what'll happen is it'll just flag us a little notification that you raise your hand and that you have a question. We'll probably be able to use that a lot closer to the end when we're doing our question and answer portion, but also if you need something from me as the host, that'll alert me to chat you directly so we can connect. We also have the question and answer feature. So if you go ahead and if you look, you'll see it looks like kind of 3 little boxes all stacked together and a uppercase Q on the front of it. What you can do is you can actually pop questions into there that you have for Jeff or for any of our board members. And for the rest of the participants, you should be able to see the questions that are popping up. And if you agree or would like that question answered, what you can do is you can upvote it. You also have the ability to leave the meeting. So let's say that you need to run and go do something else. There should be a little box in the corner that says leave meeting that you can go ahead and click. The nice thing about our session is that it's going to be recorded and we're going to be posting it on our communities. We'll be posting it on our Facebook page. And we'll also be sharing it as a link directly on our COVID-19 resources page. So with that, I'm going to hand it back over to JT, who will be able to do an introduction for Jeff, and then we'll jump into the meat of our session today.
I'll just get back on video here. There we are. So it is a huge pleasure to welcome Jeff Tenenbaum. He's been amazing support, and I know he's rearranged his schedule to support us today. So thank you very much, Jeff. Jeff is managing partner of Tenenbaum Law Group. He is an experienced not-for-profit and association lawyer. He's going to share some legal strategies for the meetings and events industry in times of this pandemic. He's got an extremely impressive CV if you want to take time to read it. He has worked for the government for many years on and off, and also he's represented associations globally. So huge welcome to you, Jeff, and I'll hand over to you, and thank you so much for fitting us in, because I know you've been very busy.
No worries. Thank you, JT. Welcome, everyone. Thanks for joining us for our program today, COVID-19 Legal Strategies for Nonprofit Meetings. So as you all well know, better than most, the last few weeks have had a devastating impact around the globe on everyone in so many aspects of life, but they've also had a hugely significant impact on the meetings industry and the events industry and the world that you live and breathe, and frankly that I live and breathe as well. I've spent my whole 25-year career in private practice representing associations and other forms of nonprofit organizations and other kind of event sponsors and organizers in connection with pretty much every aspect of their legal needs, including, of course, meeting contracts. And so meeting and event contracts, hotel and convention center contracts is an area in which I've always had a huge focus, have represented hundreds and hundreds of associations and nonprofits in connection with their various event contracts and negotiations and liabilities and insurance and everything else in between. Not surprisingly, over the last 3 weeks, my colleague and I have been working probably 16-hour days every day to work with kind of well over probably about 150 associations and nonprofits over the last 2 or 3 weeks in connection with their upcoming events and all the decisions that have to be made about canceling, postponing, and otherwise trying to mitigate the financial and legal and other fallout from the impact of COVID-19 on these events. These are really difficult, complicated issues. They're made more complicated and difficult by the fact that things are changing on a daily, sometimes even hourly basis. I know this group is very much international and from around the world. And while I represent many organizations that have operations around the world, they're all largely based and headquartered here in the US. And so I do want to caution you that my comments and remarks and general experience, while some of the associations and nonprofits we've been helping recently are in connection with overseas meetings, most of these meetings and thus most of the experiences from all sorts of negotiations and contract reviews and everything else we've been doing is going to have a US focus. In terms of legal principles like force majeure and other things we're going to be talking about, it also comes from the US legal perspective. There are a lot of analogies with the comparable analogous laws in other countries, but I do want to caution you as to that. Certainly though, while the nuances of the law are going to differ from country to country, a lot of the focus of today's webinar is going to be on strategies for how to effectively deal with these issues, and those strategies are going to be largely the same from one country to another, and certainly very applicable and analogous. So Marley, if you can move on to the next slide. This is the agenda for what we're going to be covering here today in roughly the next hour. And as Marley said, please pose your questions in the Q&A box, not the chat box if possible, in the Q&A box. I am not going to get to those until I get through these PowerPoint slides in roughly an hour, maybe 50 minutes, depends how we get through this. And I just lost the screen. Oh, there it is. But then I will do my best to answer all of your questions, or at least most of those questions at the end. So the focus of this webinar is not on all impacts of COVID-19 or all legal impacts, but a focus on meetings and events. And I shouldn't have put the word nonprofit. It's really on all meetings and events. And frankly, whether the event organizer is a nonprofit or a for-profit, none of that really comes into effect. The same issues, the same analysis, the same legal principles are going to apply regardless. The principal focus is going to be on meeting contracts, and then maybe a lesser focus on event cancellation insurance. I'm going to talk a bit about the difference between contract law principles, or contract law provisions, and common law principles in the US, of course. I'm going to talk a lot about and do a deep dive into force majeure contract provisions. I'm going to talk about options to cancel your meetings and events without penalty, or to be able to try to reduce penalties. I'm going to help you strategize a lot on kind of the pros and cons of canceling now, or waiting to cancel, or attempting to postpone your meeting. If you do proceed with rescheduling the meeting for several months from now, what steps can you take to both reduce attendee risk and reduce risk to the event sponsor? I will talk a bit about event cancellation insurance, commercial general liability insurance, and workers' compensation insurance, again with the US focus. And finally, give you some best practices for negotiating future meeting contracts. Next slide, Marley. So I know you're all in the events business. You've all heard the term force majeure. Until now, and I don't know how much of you have been deeply involved in working with your organizations or your clients in connection with their upcoming event contracts. But if you've been involved in any way now or over the years, you're probably very familiar with this principle, this concept of force majeure. To be frank, it's one of those provisions in most meeting contracts. And by meeting contracts, I mean agreements with hotels, convention centers, event venues, theaters, restaurants, as well as vendors. A lot of the large meetings and conferences have a lot of big vendor contracts as well. And this is a provision that frankly should be in all of those contracts. It's a term that technically means overpowering or irresistible force, but it's essentially a legal concept that says that if some unforeseen event happens that makes you unable to perform your obligations as you were expected to perform under the contract, then you can be excused from performance under that contract. That's the basic principle. As you might imagine, the devil's in the details. So this principle is rooted in what's called common law. This is kind of like court-made or judge-made law in the U.S. And this principle has existed for many, many years. And even if you had a contract that did not have a force majeure provision in it, at least in the U.S. And in many other countries, you have this common law doctrine of force majeure that if, for instance, you're supposed to hold an event in a city that's devastated by some natural disaster and the convention center and all the neighboring hotels are shut down for a month, and that's during the month that you're supposed to hold that event. Even if you had no force majeure provision in the contract, you would be able to be excused from performance without liability under that contract because of that force majeure event happening. Now that's an extreme example where it's literally physically impossible for you to hold the event, and you would be excused based on that force majeure common law doctrine, that principle. But what has happened over many years in the US is that the force majeure concept has been codified in contracts, and it's a provision that gets negotiated between the parties like every other provision or most other provisions in a contract, to say that as written, if the conditions of this provision are satisfied, then either or both of the parties are able to be excused from performance altogether under the contract. And so the devil is very much in the details because not all force majeure clauses are equal. Far from it. I've reviewed, and my colleague has reviewed, hundreds of force majeure clauses in the last 3 weeks. There are some commonalities that I will talk about, but they're all a bit different, and even a one-word difference here or there can have a huge impact, some words more than others, which I will talk about. I will also talk later about when you're negotiating your future event contracts, how I think the landscape is going to change in light of this virus, in terms of how both sides try to approach these provisions. Like I said earlier, while these provisions have historically been one of the least focused on provisions in meeting contracts, I see that being a very different situation going forward. And these provisions have been critical and central to every analysis. Every time we have a new client that comes to us and says, all right, we have another meeting event, we need your help in analyzing the situation, the first thing we do is, it's always in the back of the contract, and we always go straight to the force majeure provision. Sometimes it's called force majeure, sometimes it's called impossibility, sometimes it's called termination for cause. Those are the three kind of most common names for this provision, but essentially it is all the same thing. And if a force majeure clause if it's applicable to your situation, and we're going to talk about what that means, it excuses complete performance of either or both parties' contractual obligations under the contract. As most are written, it does not exclude partial performance, and we'll talk more about that in a minute. Next slide, please. So because each provision is different, if you have large events, and a lot of my clients, say US-based trade professional associations that have very large conferences, and they'll take over a downtown convention center in a major city, and then they'll have 10, 15, 20 different hotels in the block for their event. While sometimes the local Convention and Visitors Bureau, especially if it's a large meeting, you have a lot of leverage, sometimes they can be helpful in negotiating some common provisions with all of the hotels in the convention center. Oftentimes, and most of the time, and we've reviewed some of these recently, every one of those provisions might be a little bit different because each one might be negotiated separately. It just varies. And each hotel is going to have their own standard force majeure provision. Even those are very different from one to the other. Of course, in general, the hotel or convention center's standard force majeure provision is going to be much narrower than the one that's pushed for by the association or the event organizer, because it's generally the event organizer, the association, that wants to be excused from performance in certain events, and it's usually the venue that wants to not let you be excused. And so that's the general way this kind of gets approached, and that's where the negotiation tends to start. Now, the force majeure analysis that my colleague and I have been doing many times a day for a number of days now, and it's going to, I have no doubt, last for many more days, we focus on two things. We focus on the language of the force majeure clause, of course, because that's critically important. And then we focus on how does that clause apply to the facts that exist kind of on the ground at that time. And those facts we're finding are changing on a daily basis, as I said, sometimes even an hourly basis. We've been on calls with clients that are holding a meeting in a given city, and during the course of the call, an email will flash over the screen saying, so-and-so city has now banned all gatherings of 50, over 50 people or something like that, or over 250 people, can have a dramatic effect on the applicability of the force majeure clause to that particular circumstance. And so how that applies to the situation literally changes every day. We've been with some clients on the phone or over email or both every single day because they want to kind of constantly reevaluate the situation. Yesterday, I think it was yesterday, every day has been running together, President Trump came out with his announcement in the US that he's strongly encouraging that there be no gatherings of people in the US over 10 people. That word encourage as opposed to mandate or prohibit is very critical. We had a number of clients who reached out and they said, okay, this is really getting much more serious. The president says we shouldn't gather in groups of more than 10. How does that affect our analysis? Well, as we're going to see, it may or may not have an effect on the analysis. It all depends on how these clauses are written. And then I'm going to get much more into this. Ideally, the force majeure clause should be tied into the attrition penalties. So the attrition provisions in a contract, in a meeting contract, and you see it both in convention center contracts and in hotel contracts. You certainly see it in other venues as well. With convention centers and venues like restaurants or theaters, it's generally going to be focused on food and beverage. With hotels, it'll be focused on food and beverage as well as sleeping room revenue. And generally what these provisions are, they're essentially minimum guarantees that the event organizer is guaranteeing to the property. We're going to guarantee you these certain amounts of minimum revenue or minimum number of room nights that you're going to be able to get from our meeting. Usually, most of these provisions give the event organizer a chance to reduce the minimums kind of over a period of time leading up to the meeting. The longer out, you generally have an ability to reduce it by a certain percentage or a certain amount. The closer you get, the less ability you have to do that. And then once you get past a certain point, you're generally locked in to those minimums and not able to adjust those. Of course, the minimums themselves are all negotiable at the outset with the contract. But as we're going to talk about a little bit later, in a situation where you have a meeting, an event scheduled for April, May, June, you're really not comfortable leaving that meeting in place. You're almost certainly feel like you're going to have to either cancel it or reschedule or postpone it because you're just not going to be able to get the attendance. Either legally people won't be able to get there, or even if certain bans are attendance bans or travel, mass gathering bans or travel bans are lifted, although there are no domestic travel bans in place right now. At least not at the federal level. Even if those get lifted, I think everyone has a pretty broad, wide understanding that you are going to have a really tough time getting people to attend, a mass gathering in May or June of this year. And so some of our clients are looking to push those back to the fall, some even to August. But there is a very real risk that even if it gets pushed back to August, yesterday, the U.S. president said that his experts tell him that this virus may still be an issue all the way through August of this year. Even if it's largely under control by then, you're still going to have great fear and trepidation on the part of many folks that are going to be unwilling out of fear or threat to attend your meetings or get on a plane or whatnot. But so you are likely going to have, almost certainly going to have reduced attendance even for a meeting in August. So what you want to do is be able to negotiate away or negotiate down those attrition penalties so that if you have less than expected attendance, you don't get penalized. Or say, even if there is a force majeure event, but you decide to go ahead with a meeting anyway, you can reduce or eliminate your attrition penalty. So you might tie it into the force majeure, and it could be separate. We've had some clients who've had success in saying, okay, we're going to rebook our meeting for August, only if you agree that there'll be no attrition penalty. So even if barely anyone shows up, we're not going to be hit for any minimums. And some properties have actually been willing to do that because there's a real sense of desperation right now on the part of the hotel industry in particular. Next slide, please, Marley. So from kind of the event planner, the association's perspective, this is, what I would consider kind of the ideal force majeure provision. From the hotel or convention center or venue's perspective, certainly not. Maybe quite the opposite. But in terms of, what you are going to want to work toward, actually, maybe it's blocked here because of the video feed. It's not blocked. I don't know if it's blocked for you guys if you have where your video feed is on the right side of the panel, but Marley, is there a way to minimize my video so that people can see the full slide? And if not, it's not a big deal.
Steve, everyone has control of their own video feed, so you can pick up the thumbnail and move it if you want, if it's in the way.
Oh, I see. Okay, got it. Okay, I actually just moved it down to the bottom, and that's a lot better. Now I can see the whole slide. So in force majeure provisions in contracts, the way I've been describing it to clients is there's kind of two different parts. It's think of it like a two-part test, and both parts of the test have to be satisfied in order for the provision to apply and for one or both of the parties to be able to terminate without penalty. So the first part of the test is there a qualifying event, a force majeure event that would trigger the clause in the first place? Almost every force majeure clause I've ever seen starts out with a reference to acts of God, and includes things like war, government regulation, disasters, fires. Some of these other things are not as common in every force majeure provision. You see that I highlighted here, just for your benefit, the word disease. Obviously, for obvious reasons, doesn't exist in a lot of provisions. It exists in some. It's something I've always pushed for, kind of from back in the days of Ebola and Zika and SARS and MERS. But maybe what's most important is this reference to about a third of the way down, or other similar cause beyond the control of the parties. And so that's a really important catch-all provision that enables you to say, okay, even if this unforeseen circumstance isn't listed in one of these listed events, at least we have this catch-all that will enable us to cover that. Certainly, a clause like that would certainly cover COVID-19 without question. It'll cover a lot of other things as well. And that avoids you from having to worry if you got everything on the laundry list, or even if the venue is pushing back on including some of those things. As long as you have that catch-all provision, you're going to be fine. The second part of the test, to me, that's where the rubber meets the road. That's the most important part, especially if you have a catch-all provision. The rest of it almost doesn't matter, or largely doesn't matter. Second part is, what is the effect of that event on your ability to perform under the contract, to perform your obligations? And there, if you look here in the middle of this clause, it says making it inadvisable, illegal, impossible, or commercially impractical to hold the event. Now, this is what I like to see in these clauses. This is what I try to negotiate. It's not always going to be there. Of the hundreds of meeting contracts and force majeure clauses we've reviewed in the last 2-3 weeks, I would say 85% of them do not have the words inadvisable or commercially impractical or anything similar. All they have is illegal or impossible. And that's because the vast majority of the hotel and convention center form contracts, their starting point, have illegal or impossible. There are some that for some inexplicable reason have this more flexible language, but most do not. I don't understand why they do. I think it's more of an oversight, or people don't understand. But most of the ones that know what they're doing, certainly, once they get their language from the corporate headquarters, have the illegal or impossible standard only. And so, as you might imagine, if you have a standard that says, you have one of these events or similar cause beyond the control of the parties that makes it inadvisable for you to hold the event, or commercially impractical, that's a much broader, flexible standard that under any analysis, under any set of facts, it's hard to imagine right now, today, on March 17th, that would not allow you to excuse performance under the contract. Well, I should put it this way. If your meeting is coming up very soon, like if it's coming up, say, in the next month, we're going to talk a lot more about what about meetings that are coming up 2, 3, 4, or 5 months from now. That's definitely not necessarily the case. You might make the argument it's inadvisable for us to hold our meeting in June because of this provision. The venue is almost certainly going to push back, and they say, how do you have any way of knowing? What if one of these labs that's working on this comes out with a vaccine and it can be widely produced and distributed in the next 2 months? How do you know that it's going to be the same situation in June? You have no way of knowing. But for the meetings that are coming up, especially within 30 days, if you have some inadvisable or impractical language in there, I think you're going to be in good shape from a force majeure perspective. However, if your meeting is further out, different story. And if your contract provision, the force majeure provision, says only illegal or impossible, the basic position that most of the hotels and convention centers in the US are taking right now is that unless it is legally prohibited for you to hold your meeting at that property at the time that you've contracted to hold your meeting, then they are going to push back and deny your force majeure position. And if you send a cancellation notice and blaming it on the force majeure provision, saying it's impossible or illegal to hold, unless there is a governmental ban that prohibits you from holding the meeting at that place at that time for your size meeting on those dates, they are going to deny it, and they'll likely send you a bill for the full cancellation penalties the next day. That's what's been happening. So in the US, as I alluded to earlier, there is no federal ban on mass gatherings of any size, and there's no federal travel ban of any kind, domestic travel ban. There's obviously some international travel bans in place. And so from a federal level, all of the guidance from the CDC, from President Trump and whatnot, these are just advisories. These are recommendations. They're very strong recommendations, strong admonitions, but they're not legally binding mandates. And that's been a very deliberate decision on the part of this administration so far, because they believe that that the situation is different in different states and cities and towns and counties across the country, and that local jurisdictions, both states, cities, counties, should be able to make their own decisions on that. And of course, as we've seen, many governors, mayors, other county executives have imposed their own bans on mass gatherings of certain sizes, even some local travel bans into some hot zones and whatnot and out of them. But it's been all at the state and local level. Some of these are imposed with an indefinite time period. Like, for instance, yesterday, the governor of the state of Maryland here, adjacent to Washington, D.C., where I live, instituted a ban on gatherings. I think it was over 250 people. And he said that this will remain in place indefinitely for as long as there is a state of emergency in the state of Maryland. So that's helpful. Say you have a meeting that's 4 weeks, 6 weeks out. That's more in Maryland. That's more helpful than, for instance, an organization that has a meeting scheduled in DC for mid-April. And I was just on the phone with one right before this call. They're also DC-based organizations. It doesn't matter where you're based. It matters where the meeting is going to be. They have a meeting scheduled for mid-April. The mayor of DC, Muriel Bowser, issued an emergency regulation yesterday banning gatherings over 250 people, but she said this is only in force through March 31st for now, and that as long as there's a state of emergency, she reserves the right to extend that, which she almost certainly will. I mean, I cannot possibly imagine she won't be extending it past March 31st, but she wants to wait and see, I guess whether she wants to, how long she wants to extend it for, and whether she wants to make other changes to it or whatnot. But right now, for that client of mine, the association that has the meeting scheduled for mid-April, I told the general counsel and then the CFO, right now you cannot rely on that. And their standard for cancellation is illegal or impossible under their force majeure provision. It's a hotel in DC. And so I said, even in the best case scenario, there's some other little wrinkles there, but even in the best case scenario, we have to wait until Mayor Bowser extends the ban to a time period that covers your period of time. And then if and when that happens, which I expect to happen, we'll be able to cancel. And like I told them, you're not going to be holding your meeting in mid-April. That's just a no-brainer. It's just not going to happen. And they wanted to know what to tell their board in 2 days. And I said, tell your board it's not a question of whether we cancel or whether we're prohibited from holding. It's a question of when we cancel and under what conditions and under what cancellation notice we provide to the hotel to make sure we don't get hit with any cancellation penalties. And we want to optimize the situation because there's a large amount of potential cancellation penalties, close to $1 million in potential cancellation penalties if they're able to cancel and not be covered by the force majeure clause. So there's a lot at stake here. And so the timing is really critical. A week ago, a lot of organizations, a lot of associations that had meetings coming up in a week or so, or even less. And they were obviously getting extremely nervous under huge pressure from their members, their attendees, to figure out what to do and to cancel. But what we were seeing is that these advisories were turning into bans on mass gatherings. That really didn't happen, if you remember, in the US until the last maybe 2-3 days when it really started to happen in earnest. And I said, you need to wait as long as you can. Sure enough, a lot of them did listen to my advice. They waited. And sure enough, the city, put in a ban of gatherings over 250 people, and then boom, they were able to cancel. And there's no question that with an illegal or impossible standard in the force majeure, in that circumstance, they were able to get out because that ban covered their period of time and their size of an event. In some other situations, the associations felt too much pressure, too much of an obligation to their members. They said, we have to cancel. I had one today. Well, it wasn't a client, it was a question from a webinar participant earlier who told me that her organization had an event scheduled in Vegas. They canceled 2 days ago. I think it was yesterday that the MGM announced that they are going to be shutting all of their properties, including in Vegas. This was an event that was going to occur at the MGM, one of the MGM properties in Vegas. The MGM hit them with a bill for the full amount of cancellation penalties, even though they are in fact going to be closed when their conference would have started this Saturday. I mean, it's quite shocking. But this is what I've been advising clients, is that the cancellation notice, your cancellation, like whatever facts exist on that date and time, and it's even time. We've had some where we're actually looking at the time that a mayor announces a ban versus the time that they gave the cancellation notice, because these properties are taking a really hard line and saying, unless you strictly meet the terms of this impossible or illegal standard, we're going to hit you with full cancellation penalties. Now, in that example I gave you with the MGM in Vegas, while technically the notice was given before the property announced it was going to shut down and before there was a ban in place, and I can't remember actually offhand because they're all running together, whether the state of Nevada or the city of Las Vegas has themselves imposed a ban. But it was certainly before, at that time there was no ban and there was no MGM announcement about closing. That is an unfortunate situation, which is why I've been encouraging clients to wait as long as you possibly can. That being said, if they were to retain me to help and battle the MGM over these cancellation penalties, I would make a very, I think, compelling argument that the MGM doesn't have the right, it would be unjust for them to collect the full amount of cancellation penalties when they would not have been able to perform anyway. Their hotel would have been closed. They wouldn't have been able to have host the conference, and it would be unjust for them to collect the full amount of cancellation penalties. Some of these battles have yet to be fought. They will be, and we'll see how some of these play out. Right now, there's just a lot of negotiations going on, and I'm going to talk about the negotiation process in a bit. Next slide, please, Marley. Okay, so as I said, hotels, convention centers, other event venues generally favor language in a force majeure clause that allows termination without penalty only if it's impossible or illegal to hold the event. And they try to limit force majeure events, that first part of the test, to a very specific, narrowly defined list without any catch-all provision. From the event organizer side, you're going to try to push for language like inadvisability, commercial impracticability. Even if you just have inadvisability or something similar, it's making all the difference in the world, and we're seeing that how these negotiations play out for that 15% of the clauses we reviewed that have the more flexible language. There have been a few venues, hotels in particular, that have really pushed back hard, but most of them, when they see the more favorable language and we make a really aggressive case for it, they have been backing down for the most part, and they're basically saying, yes, we concede, but we'd really love to have you, and we'll make it worth your while if you agree to book a future meeting. So I'm sure you've all heard the announcement today from Marriott International about massive layoffs and furloughs in their properties and in their company, and as a result, and it's a sad and terrible thing, and we're all very sympathetic to it. And there's economic fallout across so many industries, including in your particular industry. That, to me, doesn't excuse a lack of enforcement of a solid force majeure provision. So I'll give you another example. While most hotels and convention centers are taking the position that illegality and impossibility is only satisfied if there's a governmental ban on holding the meeting at that time at that location for that size group, I don't agree with that position. There are other things that can make it impossible for you to hold your event. So for instance, I have a lot of association clients in the healthcare space, medical societies, have a lot in the higher ed space. In both of those industries in particular, for at least probably a couple of weeks now, certainly more every day that as the last couple of weeks have played out. A lot of those institutions, I'd say the vast majority of those institutions, have had travel bans or effective travel bans on their employees' ability to travel for a variety of different reasons, and very good reasons. If you have a situation where you can document that a vast majority of your attendees, your registrants, are banned by their own employers from attending the event, or like some universities haven't completely banned, but they made it so difficult that's when I refer to like an effective ban. I think that's an extremely compelling argument for meeting the impossibility standard. But next slide, please, Marley. You want to be able to prove it, okay? Because the hotel or convention center is likely going to push back and say, well, we're not just going to take your word for it. And you'll see, I think it's the next slide, there's a reference to doing some kind of polling or surveying, what some of our clients are doing of their members, particularly in the healthcare and the higher ed space, to try to get a sense as to how many of those institutions have institutional travel bans in place, which would prohibit their folks from attending. So there are other bases for pushing back, particularly on the impossibility standard. There's also, I referred at the beginning to this concept of this common law force majeure principle. There's another kind of related common law principle called frustration of purpose. And that is it's a very long-standing, widely understood principle that says if the principal purpose of your event is being frustrated by unforeseen events outside of your control, then legally you should be excused from having to perform under the contract. And this is irrespective of what's written in the contract. It's just a common law doctrine. Although some of the case law in this area suggests that that purpose needs to be reflected in the contract itself if you're going to take advantage of it. While hotels and convention centers are certainly right now in the US, at least not buying this as a kind of an excuse for no penalty cancellation, it is a valid doctrine. It is something that we have put in virtually every cancellation notice to hotels and convention centers that we've drafted. And in the event that some of these cases get litigated or arbitrated down the road, it may be a very important doctrine that you certainly want to be able to take advantage of. And essentially, when you're going to cancel, and let's go to the next slide, you want to be able to make as many different alternative arguments as you can for why you're canceling and why it is impractical, inadvisable, illegal, or impossible to hold your event. So now we're going to kind of do a deeper dive into kind of cancellation options and negotiation strategy. And this is what my colleague and I have been spending so much time on, particularly in the last 2 weeks, sometimes on same clients every single day, kind of revisiting the circumstances. So I said you always start with the force majeure clause itself in the particular language, but it's so much more than that. You obviously have to look at the facts on the ground in that city, in that state, in terms of the timing and in terms of the number of attendees. And even, some of the states now, some of the cities are changing their affected population from, mass gatherings have started with 1,000 and then went down to 250, and now some are reducing it down to 50. All of that makes a big difference, particularly for smaller gatherings. And the time period for which it applies matters. Even if you have, like in Maryland, an open-ended ban, if you were going to try to rely on that to cancel a meeting in June, as I said, I don't think that's a reasonable position to take. So in many of these instances, waiting is going to give you a much stronger position down the road. This third bullet point talks about the polling or surveying that I just talked about, so that you have a lot of documentation. Essentially what we're looking for is like a belt and suspenders approach. So there are all these different things that are leading to your decision to say it's impossible or illegal or inadvisable to hold the meeting. While things like the president's announcement yesterday about advising against gatherings over 10 people, the CDC's announcement the day before advising against gatherings over 50 people, while these things may not be legally binding mandates, they're certainly relevant. When they're coming from the President of the United States and the Centers for Disease Control and Prevention, these are very relevant considerations. We actually have seen today we saw one hotel that actually agreed to force majeure based on the CDC's guidance. Even though it wasn't binding, they recognized it was relevant and should not be ignored. Most venues are not taking that position, but it's still all relevant. So you want to kind of throw everything in there that's potentially relevant to your argument into that notice. Don't just say we're canceling, it's not fair to our attendees, we're looking out for their health and safety. You can say those things, but then you need to back it up with as many strong legal positions as you can as to why you're canceling. Now, in the past, when we've had a lot of other crises that have thrown these big meetings and conferences into doubt, and whether or not you could hold them, and what's happened in kind of each and every one of these, from natural disasters to disease to other things, is that to 9/11, and the most immediate impact, like the immediate fallout in the immediate area, geographic area, no question. When Hurricane Katrina, came through New Orleans and the New Orleans area, meetings that were going to be held there, in the subsequent, month or two, there was no question that force majeure applied and they were able to get out without penalty. Where we saw the big complications and difficulties in these negotiations when, 6 months later, or maybe it's 9 months later, I really don't remember the timing, but a certain period of time later, when New Orleans said, we're open for business, at least downtown, I remember. But a lot of folks, a lot of associations were still very apprehensive about going there because of, health and safety conditions and whatnot for their attendees. And the city was saying, the hotels and convention centers were saying, no, we're open for business. You have a contract obligation. We're not letting you out of that. Back then, the way that we were able to, for pretty much the whole 25 years I've been practicing law, generally you could usually, not always, but you could usually avoid or significantly mitigate cancellation penalties by renegotiating a future meeting, moving that meeting back to another date, or canceling and rescheduling, a future annual conference at that event. A lot of larger associations book these many years out, but saying our next open year will book with you. You would a lot of times get kind of the corporate headquarters of the hotel chain involved. They would intervene and help, and then we would be able to negotiate away most of the cancellation penalties. That's not the position that most hotels and convention centers are taking right now. We had one yesterday that said, if you agree to rebook your meeting within 12 months at our property and agree to book 2 additional ones at our property, then we will let you avoid your cancellation penalties. A lot, at least over the last week, have been saying, no, we're going to hit you. And these are almost all that have an illegal or impossible standard in the force majeure clause. They're saying, we're going to hit you with the full cancellation penalties, but if you book another comparably sized meeting at our property within the next 12 months, we will apply 25% of your cancellation damages to the payments you would owe us for the new meeting. Not particularly helpful. That being said, in the last 24 to 48 hours, we're starting to see a little bit of loosening on the part of some of the properties, being more flexible. I think recognizing that there are going to be more and more kind of ironclad force majeure cancellations coming, and recognizing this is going to be an incredibly difficult time for the industry, for the hotel, convention center industry, but that there will come a time, hopefully sooner rather than later, where the industry can rebound and they want to have as many meetings booked to kind of fuel that kind of comeback as possible. And so we are seeing a little bit of a shift there. At the same time, there was a client I was working with a lot yesterday, large national association. I'm not going to mention their name or the name of the property or the hotel chain or the city, but the CEO did give me permission to talk about this on today's webinar. And we sent, I think it was yesterday morning or early afternoon, force majeure cancellation to the hotel. It's an impossible or inadvisable standard, but we had some really compelling evidence, not an applicable ban, but a lot of other evidence, including the vast majority of attendees being prohibited from attending the event, vast majority. The hotel sales director wrote back a 2-page single-space letter that really kind of took us by surprise, and it was actually pretty galling. And I want to read to you kind of an excerpt from it. While there has been a great deal of recent publicity regarding coronavirus, currently this situation is essentially no different than other health advisories issued by organizations like the CDC or the World Health Organization. Let me say, this is a major brand, part of one of the biggest hotel chains in the world. These organizations report outbreaks of various types of influenza, West Nile virus, and even measles, all of which occur in the U.S. We will continue to closely monitor coronavirus updates and respond based on the advice of governments, public health authorities, etc. However, generalized risk of communicable disease is a fact of life and therefore not an unanticipated circumstance that will entitle a party to invoke force majeure under current circumstances. That's what was written to my client yesterday. Needless to say, it really set off the CEO last night, and the CEO and I went back and forth for actually a couple hours on a response letter, which we sent off late last night and copied a number of other key people. I just want to let you know that even in the fact that we're dealing with this unbelievably horrible crisis and all the circumstances that are going on and everything we're hearing from the White House and elsewhere, that's the response we got from one of the biggest hotel companies in the world. So don't assume that just because we're dealing with these crazy, horrible circumstances that the hotels are going to be flexible. They have a lot at stake. I recognize that. They're going to be have huge losses and huge layoffs. We heard it from Marriott. It's going to occur with other hotel chains as well. We're all sympathetic to that, but there has to be a middle ground here as well. Obviously, I'm a little biased in representing the associations and event organizers. I don't represent the hotels and the venues, but needless to say, there has to be some kind of reason and rationality in these decisions, in these negotiations. One other point at the bottom of this slide, and I apologize, I don't know why the text is kind of moving on, running over into the footer there, but another key consideration in these negotiations, these cancellation decisions and options and timing is, do they have your money? I should also say, do they have your credit card? Because if you have a situation where the venue, the hotel, convention center has a very large deposit from you, and you exercise your force majeure rights, they disagree, they are not only going to issue you a bill the next day, most likely, for all the full amount of cancellation penalties, but they're also going to keep your deposit and apply it toward it. And if they have a credit card on file from you for guarantees, they're going to charge it for whatever amount they can charge to it. We've seen it happening already. I have one client, it was not my recommendation to them, but they went, when they had a feeling this was going to come to this, they canceled the card that the hotel had on file. After the cancellation notice was issued, the hotel went to try to charge the card, obviously didn't go through. Believe it or not, someone from the hotel reached out to my client to say, oh, we lost the card number that we had on file for you. Would you mind giving it to us again? Needless to say, my client did not cooperate, and they will be battling it out, as many associations and event organizers are going to be over the coming days and weeks and months. Next slide, please. So kind of part of the continuation of the same discussion, do you cancel now? Do you wait to cancel? Do you wait to attempt to postpone? One of the important points I want to make here is that most of these meeting contracts do not have a contractual right for the event organizer to postpone. In fact, I've never really seen one. And as a result, if you go, I had a few clients this week that said, well, we told the venue that we're going to postpone the meeting, but we didn't tell them that we're canceling it. Postpone is not the same as cancel. And by the way, I want to make one comment. I just saw something pop up in the chat feature. I do want to say, someone said, not all of the venues are acting the same as that letter I read from yesterday. I absolutely see that. Every day that goes by, especially starting yesterday and today, and I've been doing webinars all day. This is my third, but my colleague has been on the phone and on an email with so many clients, and the little bits and pieces I've seen even today, there's been a lot more flexibility from a lot of the properties, and a lot of them are being very reasonable and flexible. They want your business for the future, and they're starting to be more reasonable and flexible, but what I read to you is not an outlier. This is exactly what's been happening for the last several weeks. I hope things are changing. I'm not trying to condemn the whole hotel industry by any means, and I'm a big fan of the industry and event venues generally, and have a lot of friends in those industries. But I'm just saying it has not been a situation where there's been a lot of reasonable, flexible, rational discussion going on. I also see, this is a good question. How is it not illegal to charge a client's card after they've already canceled? This is why I did not advise that client, they did this on their own, to cancel the credit card. If the contract says you have to provide a credit card for guarantees, you cancel the event venue disagrees that it's a force majeure cancellation. They believe it was basically a cancellation without cause, and therefore you owe the full amount of the liabilities. The contract actually provides in those cases that if they have a deposit or if they have a credit card, they're allowed to charge it. So I'm not saying that the venue or the hotel is acting unlawfully from doing that. And I never finished my point on this. What I was saying is that who has the money and who has to come after whom for the rest of the money, whether it's cancellation penalties or the rest, makes a huge impact on the negotiating leverage of the parties. It's just the reality of the situation. And so if the hotel has no deposit or a very small deposit and you decide to cancel, you believe you have a strong force majeure position, they disagree, they send you a bill for the cancellation penalties, then they have to come after you to pursue those. And I'm not suggesting they won't. I think they're going to need to in the current economic climate that they face. But the burden is on them to pursue you, as opposed to if you had given them, a 50% deposit or more. Every one of these situations is different, and you had to pursue them and sue them in order to recover your deposit. That's a very different calculation. And in that latter situation, you're going to be much more probably willing to negotiate with the venue to reschedule a future event to try to mitigate those cancellation penalties than in the situation where you believe, hey, we have a really strong case. Maybe there's a mandatory arbitration provision in the contract. Let them come after us. We will gladly argue our position. I've had a number of clients tell me that and say, and we have an attorney's fee provision in there. It says if we prevail on the arbitration, we get to collect our attorney's fees from the other side. Some organizations are making that calculated decision that that's the position they're going to take. I see your comment. We all need to work together. I completely agree with you. And there have been many, many negotiations that we've been involved in that have been very amicable and flexible, especially this week. But that's not been the case for most of them. Most of them have had, at least up until now, hopefully things are starting to change, a very, very hard line in the sand. And so while I'm saying might sound, difficult and uncomfortable and even a bit aggressive in these very difficult times, I'm aggressively advocating for my clients in a situation where we're trying to get the best outcome for everyone. And the best outcome means we have future meetings with these venues. And we all know we're not going to be able to hold meetings over the next few months. But if we do decide to hold a meeting in August, we want you, event venue, to be flexible in the event we don't get the attendance that we think. And ideally we get to a situation like that. But right now, when we're not there in all of these venues, then we have to, whoever has the most leverage, whether it's who has the money, whether it's a lot of other things, is going to make a big difference in the strength of your position and whatnot. So timing, this issue of when you wait to pull the trigger, and the fact that whenever you pull the trigger on that cancellation notice, it kind of locks in, for the most part, the facts that are on the ground that are in place at that particular time. That's a critical issue. And I gave you the example earlier, the MGM. We've seen that in a few other cases. We had a few other cases where our clients decided they needed to cancel, they couldn't wait anymore. And then the next day, there was a city-imposed ban on events like theirs. These are difficult situations. So far in those situations, the venues have said, sorry, you owe us the full amount of the event cancellation penalties, and they have not backed down from that yet. And then finally, at the same time, there are, like I said in those examples I just mentioned, sometimes there are other considerations, not financial, that now the clients have told me, look, we just don't have any choice. We can't wait any longer. We have to pull the trigger. Next slide, please. And by the way, I do recognize, and I said this to to JT and others at ILEA coming in. My experience is primarily, almost exclusively, in the association and the nonprofit side. I do represent some for-profit corporations that have connections to nonprofits in various ways, but I am not I don't do work on the corporate event side. And so to the extent that some of the dynamics, some of the culture, some of the patterns of how these things play out may be different in that world, I self-admittedly don't have the experience on that side, so I'm not trying to paint an overly broad brush. Just like in the beginning, I said that my experience is largely U.S. based, at least in terms of where the events are being, or where the organization that sponsor the events are located. Similarly, my experience is not in the corporate events side. So please take what I'm saying with a grain of salt. If the circumstances in the corporate events world differ in a lot of respects from what I'm talking about. So if you decide to proceed and reschedule your event for, say, several months from now, July, August, September, which a lot of organizations are considering doing, because a lot of hotels and convention centers are saying, if you do that, we'll give you a really good deal because we want to fill our properties then, because they're still expecting there's going to be a lot of empty rooms, empty ballrooms and other things. Obviously, there's going to be a lot of uncertainty. We just don't know what the situation is going to look like. So if you decide to do that, know, A, you're taking on some risk. B, you want to make sure that your contract is very much written in a way that helps to mitigate your downside risk in the event you don't get the attendance that you hope for, whether it's attrition penalties, cancellation penalties, or the rest. And I have seen some real flexibility in a lot of hotels in particular in being flexible in that regard, because they do want these future bookings. And then another issue I've gotten a lot of questions and concerns about, and this is going to apply whether it's in the association world or the corporate events world, is what about liability to the event sponsor? So say we decide to hold an event in August instead of April, and we push it back, and there's no widely available vaccine at that point. For the virus, the curve has been flattened, but there is still a risk out there. Testing is not 100%. Not everyone is going to get tested. And so someone attends your event, they contract, or they allege at least that they contract the virus at your event, and they decide to bring a legal claim against you, maybe against the event venue as well, probably both, saying that you were liable. A, you held the event too soon. B, you didn't follow all the proper precautions and protocols, etc. How do you prevent yourself from liability? Well, first off, I think there is going to be some real liability risk, but there are some ways to mitigate that. First off, and I think maybe the most important thing, is to make sure in your contract with the venue, say it's a hotel, that you not just have the usual provisions in there about the hotel represents and warrants that it'll be, safe, clean, etc., warranty of quiet enjoyment for guest rooms, all of that sort of stuff, but that you go above and beyond that and have very specific reps and warranties on the part of the event venue, that they are going to do all these different things, even putting them in the contract itself, that they're going to do to help make it a very safe event from a COVID-19 perspective. You also want to get them to indemnify you and hold you harmless in the event that they don't do all those things, and you get sued as a result. And if it's clear it was the hotel's negligence that caused that, then in that kind of situation, you want to make sure that they step in and protect you, pay your legal fees, pay your judgments against you. You want to do your due diligence in terms of one or more site visits in advance to make sure all of those protocols are in place. We had a few clients, it was probably 2 weeks ago now, where the venues really were pushing hard. It was kind of before things really got out of control, and they were really pushing hard from the associations to hold their meetings at their venues. In one case, the staff and the meeting planner, the outside meeting planner, went down and did a site visit, and there was not even barely the slight, other than a bunch of hand sanitizer everywhere, there's not the slightest bit of protocol, signage, answers to questions about what happens if this and that. It was just an absolute mess. And in that situation, it would have been incredibly negligent for the organization to hold the event at that particular property. Even then, 2 weeks ago, the CDC had come out with this published guidance for mass gatherings and large events. There, the property wasn't even following half of those things in there. Certainly, that creates a standard, and I am presuming the CDC will update and probably expand on those guidelines, in the future when meetings start to happen again. Making sure you follow those standards, the event venue follow those standards, is going to be very important for helping to show that you were not negligent. That due diligence is going to be helpful. So if you do all of those things and someone does suffer some harm, they contract the virus, they get quarantined as a result, and they suffer harm, they lose income, at least you can show that you did everything reasonably possible to try to mitigate that liability. Next slide, please. Okay, finally, the last few topics here, event cancellation insurance. So event cancellation insurance, I'm sure all of you are very well aware of, it's been around for a while, can be critically beneficial, but has a lot of limitations. The definitions, the exclusions, and the limitations are all critical to analyze, and it can be a complicated analysis because sometimes you'll have a provision in the core policy itself that has an exclusion, and then you'll have an endorsement that the event organizer purchases to basically override that exclusion, kind of buy it back essentially. But then that endorsement itself may have some exclusionary language in it. And you have to look how you can't ever look at one provision in isolation. You have to look how they all play out. And so, for instance, there are 4 leading event cancellation insurance policies in the U.S. Showstoppers, Expo Plus, HCC, and Beasley. As of mid-January 2020, all 4 of those policies expressly excluded coronavirus from coverage. So even if you purchased an endorsement that gives you coverage for communicable diseases, coronavirus is expressly excluded. And so you cannot purchase coverage in the US anymore for any coronavirus related claims. But for policies that were in place prior to this year and that cover events that are occurring this year, if so 2 of the 2 biggest or most purchased policies are the Showstoppers policy and the Expo Plus policy. Both of those policies in 2003, after the SARS virus, they put a communicable disease exclusion, very broad exclusion, in their core policy. But then they came out with an endorsement saying if you want to purchase this endorsement, generally costs maybe 20% of the total premium. That's kind of some of the numbers I've seen. Not an exact science, and they calculate it in different ways, but generally it costs you about a 20% extra to get the communicable disease endorsement. If you purchase that, then you do have coverage for communicable disease. Although even, if you purchased it last year, for instance, that endorsement contained an exclusion, not for coronavirus, but that said, if the reason that you're canceling is based on your attendees' fear of attending or threat, the fear or threat of contracting the virus, then that's you're not going to have coverage. And so up until we had the point when a lot of states and cities and counties were imposing bans on gatherings of certain sizes, the insurance carriers were saying, look, if you're canceling, it's only because your attendees are fear or threatened to come. We were making some arguments that no, if the vast majority of their attendees are banned from coming by their employers, that should satisfy the standard, and that it's not based on fear or threat. They're just literally unable to come. It's essentially analogous to the impossible or illegal standard in the force majeure provisions that I was talking about earlier. Now though, so if you did purchase that communicable disease endorsement, and now you're in a situation where your meeting is illegal because the city or state shut it down during your period of time, you actually would have coverage or should have coverage under those policies. That's for the Showstoppers and Expo Plus. For the HCC, and I've yet to see a client of mine that has the Beasley policy. For the HCC policy, the Houston Casualty Company, they never imposed any, until now, they never imposed any exclusion for communicable diseases, probably to give them a competitive advantage. But they did define cancellation much more narrowly than the other 2 leading policies. And they define it as being physically or legally unable to hold the event. Again, kind of analogous to the illegal or impossible standard. I have had some clients that have filed claims now for events they've had to cancel, and so far I've yet to see how HCC is going to process those claims. Next slide. So I've actually already covered the first point. The second point's really not that relevant. The third point is relevant, and that is one of the advantages or nice things about event cancellation insurance. Certainly it has a number of exclusions, and there's a lot of other ones in there too. But it still does cover a lot of things, and things that we can't even foresee right now. The good thing is that all of the policies cover not only cancellation, but they cover costs related to postponement, and which is obviously very relevant right now. And they also cover costs for what's called enforced reduced attendance. So if you have coverage for an event and you decide to go ahead with it, I'm going to say it's an event for this coming August, you decide to go ahead with it, you have coverage, there's no, this was bound last year, so there's no coronavirus exclusion. In the in the event that you have fewer attendees than possible, the policy will make you whole for what your lost profits would have been, and those profits and dollar amounts are spelled out in the policy itself when you purchase it. And so basically, event cancellation insurance will make you whole for your lost profits, even if you decide to go ahead with a meeting. That's very important. And generally speaking, it's important in that I talked earlier about force majeure, being able to, if it applies, to get you out of the cancellation penalties. What it does not help you to do is make up your lost profits. But if you have event cancellation insurance, that is designed to make up your lost profits. Next slide. Home stretch. So commercial general liability insurance in the US, all of these, what we call CGL policies, are pretty much the same. It's all based on the same standard form. There is no exclusion for communicable disease in the standard CGL insurance policy. So if you get a claim from, say, an attendee attending an event, and they claim that you were negligent and they contracted the virus at your meeting, to say something coming up later in the year, your CGL policy should at a minimum step in to fulfill their duty to defend, which means they would have to pay your legal fees. Whether they would have to pay any ultimate judgments against you or any settlements that might result is a different story. Most of the insurance brokers I've talked to expect that the carriers who are facing claims like that are likely going to deny coverage for the ultimate judgment, saying, how can you prove that someone contracted the virus at our event? But at a minimum, you should have coverage for the legal defense costs, which is very important. Next slide. And then finally, for your employees, similarly, if you're whether it's at an event or whether it's just in the course of their job, and you ask them or require them to go do something, in that kind of a situation, again, the standard workers' comp insurance coverage in the U.S. does not have any exclusion for communicable disease. So if one of your employees contracts the virus in connection with their work duties, you should have coverage. Should, I say this because we really don't know for sure, and insurance companies are all over the board sometimes in how they process and deal with some of these claims. But on the surface, there is no exclusion for communicable disease. And then the last slide. So future meeting contracts, again, this is all from the event organizer perspective. Focus heavily on the details and nuance of the force majeure provision in your meeting contracts. Try to get it as broad as possible. I have no doubt this is going to be a really hotly contested provision on both sides in meeting contracts for the foreseeable future. I think this is really important. It's never really happened in the past, but try as much as you can to tie it into the attrition clause so that if you do move ahead with meetings and you have significantly reduced attendance, whether it's by tying it into the force majeure clause or just being able to reduce or eliminate attrition clauses, penalties generally, or be able to reduce your minimums for room nights and food and beverage down to a very low number, pretty close to the meeting, it's going to be really important to help cover your downside risk, particularly in the first months after meetings start to occur. If you can, state the principal purpose of the event in the contract itself so you can help support a frustration of purpose claim. And then finally, despite the fact that you're not going to be able to get insurance coverage, for, event cancellation insurance for coronavirus related claims, there are still a lot of other important claims that it can cover. For your larger events in particular, I strongly suggest you consider looking at event cancellation insurance. Look at the different carriers. Don't just go with whoever your broker might try to point you to. Look at the different ones. As I told you, HCC is very different from Showstoppers and Expo Plus. Evaluate, get quotes, compare and contrast, and try to negotiate the most favorable definitions, endorsements, and exclusions. Next slide. That is the end of my presentation. I did see a number of comments, that it would be helpful to hear some of this from the venue side. As I said earlier, unfortunately, I can't speak to that. I am not in any way anti-venue. I just don't have those experiences. There are folks, I've been reading some articles from some lawyers that only represent hotels. It's interesting to see their perspective. I just happen to represent the other side, and so that's the experience that I'm speaking from. It probably would be worthwhile, and I recommend to JT and others that you consider having a lawyer or others, maybe multiple others from the venue side to speak to these issues as well, to hear their perspective. I think it would be very helpful for you. It's not an us against them. I do agree with some of the comments I saw that we need to find ways to work on this together. I could not agree more. The clients of mine that have been the happiest in a really unhappy time are the ones that have been able to work out a good deal with the venue for rebooking future events and avoiding cancellation fees. That's what we try to get to. No one wants to be in these ugly legal battles going back and forth. I do think, though, you are more likely to get the best negotiated outcome if you have the best leverage and make the best decisions. Things like that about your timing of when you cancel, the reasons why you cancel, all of that. But in the end, having a good, solid, fair, reasonable, negotiated outcome between the two, I think is going to be the best for everyone. So why don't I stop there and see what kind
Jeff, just to jump in real quickly, sorry, this is Sarah from the Board of Governors. There's certainly the venue issue. There's also the vendor issue, because a lot of our members are suppliers. And so I just wanted to bring up two things. One, as Jeff mentioned, there are just going to be legal conversations that everybody has to have depending on the particulars of their agreements and that sort of thing. But tomorrow's open forum will also cover a lot of best practices for how a lot of businesses, large and small, are starting to treat some of these things. Everything from moving to a retainer model with some clients to see if they can get immediate cash flow to help them in the short-term situation, to figuring out about rent deferments and other things. So just so you know, we will address some of that from a practical business application tomorrow as well.
Okay. Yeah, and when I mentioned venue, I was referring to vendors as well. I should have clarified that. So anything I said about venues kind of applies to the vendors as well. All right, let me go through some of these. Some of these are more technical. Like, can we get the force majeure text in a text format to be able to add to our contracts? I'll leave it to Ilea to provide it to you. I provided the presentation in PowerPoint format, so it should be easily able to be posted in a way that you guys can copy and paste. I do want to speak to the issue of, this is a question about refunds from the venue's perspective. I can't really speak to that, but the issue of refunds from the event organizer perspective, that's been another big issue that's been discussed. For larger event organizers, associations or whatnot that have some deeper pockets, they've pretty much across the board said, look, if we're canceling, regardless of whether we're stuck with cancellation penalties or not, we're going to refund you, your registration fees. And if you want to apply it to a future conference, we would love you to do that. But if not, just let us know and we're going to refund your monies. Some are also doing that for exhibitor, registration fees and sponsorships, monies that have already been paid. Some are taking a bit of a harder line there and not just refunding them, but negotiating with them to try to get them to apply it to future events. I don't know if I know of any who have just said, we're going to keep those monies. But these are difficult decisions, and they become more difficult, what I've seen, for the smaller organizations that just don't have the deep pockets. I have one client, a smaller client, that told me, look, if we have to refund all of the registration fees that have been paid, we will go bankrupt. We will be out of business. And so, I advise them a couple of things. Is that A, be really honest with your membership and your attendees, your registrants, about what's happening, and say that to them. They generally know your cash position and your reserves or lack thereof. Be honest about it, and urge them to apply the registration fees to a future meeting. And secondly, what a lot of organizations are doing for a variety of reasons, and this is more on the association side, is where there's a key educational component to the conference. Sometimes even exhibitions. There are these things, kind of these virtual exhibitions and whatnot, but especially on the education side, a lot of associations are still holding, a virtual conference, at least for the educational component, and sometimes for some of the other components as well, and in the election of officers and directors and other things like that. Holding a virtual component of the conference, while it really doesn't help you with any of the issues that we spent this webinar talking about, it can be helpful in still, carrying out your mission and purpose of educating your members and others in your industry or profession. And it also can be helpful if you want to participate in this we're going to charge you 50% of what the registration fee would have been. That's a way to try to recoup some of those revenues. And so it's something that I'd urge you, those of you in that boat, to consider. Here's a question about incentive trips, but that's not an area that I really have a lot of experience with. The issue that keeps coming up for me is clients asking to get their deposit returned, even though it was, quote, non-refundable. Yeah, I have other clients who prepaid an entire invoice and are asking for that money back. Keep in mind, I'm a photographer, so my invoice is much smaller than other vendors. Yeah, this is what I was talking about earlier, and kind of that analogous example maybe is that smaller association I was referring to. And, frankly, in like most associations that have that hold conferences have a cancellation policy, and they say that if you cancel before this date, your registration fee is fully refundable, but after this date it's non-refundable, or after this particular period of time it's 50% refundable, and then after this date it's not refundable at all. Well, what I've been seeing is that regardless, those policies are kind of being thrown out the window for at least those associations that can afford it. And they're just realizing that is not a tenable position to take in this climate. But for the question, or the photographer, with the smaller invoices and those monies, to have to refund all of that, while the clients who paid for that may feel that that's just and proper from your perspective, that can be financially devastating, especially when you're not doing any work right now for the foreseeable future. So, these are all really difficult questions. I don't have answers for them. Like I told that other smaller association client, be honest with your clients about the situation. But I don't have any silver bullet for you. Yeah, we've never have upset customers, but as a small business, I can't afford to pay everyone money back. Please help. I very much sympathize with you. Do we think there will be a way to go back and add some of these risk mitigation provisions for multi-year contracts that are in the middle of the contract right now? Yeah, that's tough. And I've negotiated and have, even some of the contracts I've reviewed in the last couple of weeks have their multi-year contracts. Unless you have either a lot of leverage in the situation, or you're going to sweeten the pot, by offering to the venue that you're going to extend the contract by, say, 2 more years or 3 more years, whatever the case may be. In a situation like that, I think it's going to be really difficult to get the venue to reopen those provisions and say, give you a more favorable force majeure provision, or enable you to reduce your attrition penalties or things like that. I just don't know what incentive they would have to do that. And if I would advise, but for instance, if you're a really critical client of theirs and they really want you to commit to add 2 more years to the contract, then it's a whole different story. You might well have the leverage. Every situation is going to be different. Let me look here. I see there was a lot of questions in the chat box as well. What, if any, liability does a group face if they had an event early on during the COVID crisis, say late February, when there weren't any travel bans or bans on mass gatherings, but there were warnings to frequently wash hands? Like, there were also a lot of warnings, cough into your elbow. There were even warnings, even I think back then, maybe not late February, about not shaking hands, doing elbow bumps and whatnot. Can an attendee come back and say they got sick and have grounds to litigate? I've been getting this question. First off, there's an issue of proof, and as we've seen, it's well, in some cases, they've been able to early on at least to kind of trace where someone got the virus, and that was also back at the time that even the CDC was saying that, or at least the HHS secretary was saying that he thought that it was the virus could only be transmitted through someone that was symptomatic, and showing signs of coughing, sneezing, fever, headaches, etc. They have since understood that is not the case, and that the virus can be transmitted through asymptomatic people. Thus the recent warnings to millennials to really stay home, to not transmit the virus. As a result of all of this, it is so difficult. It's virtually impossible in most cases to be able to prove from whom or where, because it could be surfaces as well, someone contracted the virus. So it's going to be really difficult to prove causality for some kind of negligence claim. And secondly, you would have to show, in order to prevail on such a claim, that the say your association, if it was an association that was the event organizer, and or the hotel or other event venue, you'd have to show that they were negligent based on what we knew at the time. And so I was advising clients who were holding meetings back then. I said, at a minimum, you need to do every single thing that's in the CDC's guidance for large gatherings and mass events. Or maybe I got that reversed. That's what they call it. I think it might still be up on their website. I said, if this is what the federal government, what the CDC is saying you need to do if you're going to have a mass gathering, that sets a standard. And if you satisfy that, it's kind of we call it in negligence liability, a standard of care. If you meet that standard of care, that's a published, established, or recognized standard of care from the federal government, then it's going to be really difficult for someone to say that you are negligent. And you didn't have the foresight. The HHS secretary was saying, you only have to worry about symptomatic people, only people that have fevers and whatnot. We now know that's not the case, but we didn't know it back then in February. So I guess the short answer to all of that is, if you were doing those things, I would not be particularly concerned about it. Let me answer one or two more questions, and then we're going to have to call it a wrap. Well, some of these questions are for you guys. Anyone taking notes on your own contracts about force majeure language? We've added a postponement fee and clause to allow clients to keep the event on the books but not get any money back. That's certainly an idea. What are your planner clients dealing for the multiple vendor suppliers they've contracted with? And I should say, this is, again, some of this I don't really have a lot of experience with, but I do have experience with, say, associations that right now are focused on their big contracts, the contracts with the hotels and the convention centers and some of the big vendors. But then you have your secondary contracts, say, for instance, with sponsors. I had a question on a prior webinar about this, about sponsors. So what are you doing with your sponsor contracts, particularly, whether sponsors, if they haven't paid any money to you already, any kind of advance deposit or whatnot, then it's probably a moot point. If you cancel the event, they're not on the hook for anything, and you move on and you go back and ask them to sponsor the next meeting or event. But if they have paid you money and you do cancel the event, then you have to think strategically. Obviously giving them back their money is one option, but if you can try to entice them to, say, apply that sponsorship payment toward the virtual educational conference that you're going to have, or the virtual exposition that you're going to have in the coming months, or the future in-person meeting you're going to have in the fall, all those things you ought to consider. Those relationships are very, very important. I see that all of the time, and you don't want to take a short-sighted view and burn bridges. And at the same time, unless you have really deep pockets, refunding all of those monies to all of those folks who have paid you advance deposits and whatnot could be really, really costly. I'm going to stop there. I need to give my voice a break. I'm going to turn it back over to JT or Marley, whoever's going to take it from here. But I appreciate all of your patience in listening through all of this. Apologize for the admittedly kind of one-sided perspective, but I did see a lot of very thankful, helpful comments on there. So I hope I was able to at least shed light on these issues, from kind of the association and nonprofit perspective, but also be able to flesh out some of these legal issues and principles, which are frankly, admittedly, very complicated and difficult to understand. Thank you guys very much.
Hi, everyone. This is Dana McCauley, ILEA International President-elect. I'm taking over for Jennifer, who's on mute while she's speaking with a client. We wanted to thank you so much, especially to all of you guys who stayed over time. A huge thank you to Jeff for joining us and speaking on all of the topics that you have such great expertise on. We really appreciate it. I just wanted to take a few minutes to remind everybody who can to join us tomorrow for the hashtag ILEA Strong Community Persisting and Rebuilding Together conversation. That'll be at noon Central Time, so obviously everybody has to do their conversions, especially on the vendor supplier side. We'll be talking together solutions oriented. And then we'll be continuing each week on Wednesdays. The timing will push back a little bit. So the next one, the following Wednesday on resiliency, will be at 3 p.m. Central Time. So all of this is being posted on the COVID-19 page. A lot of questions were coming up in the chat about posting the video of this session. So Jeff, thank you again for agreeing to share your expertise with the entire world. We will be doing that as soon as possible on all of the different platforms. So huge thank you.
Dana, can I interrupt? I'm gonna sign off, but thank you again to you, JT, Marley. Great job in organizing this, and thanks to everyone for participating.
Fantastic. All right, everyone. We will look forward to seeing those of you who can join tomorrow and continuing the conversation. Thanks again for joining today.